Guys, have you considered that Shetima's double nomination might be a serious problem for Tinubu?
There's the issue of the vice presidential candidate, taking the Peter Obi petition. The issue of the vice presidential candidate. Can you be, well, Section 35 of the Electoral Act says you cannot be nominated for two different constituencies or by two different political parties. Those things are clear. And it is alleged that the vice presidential candidate, Shetima, was nominated for two different constituencies. One, the senatorial district in Borno, and the second one is the presidential constituency. The whole of Nigeria is one constituency, and his senatorial district in Borno is another constituency.
So guys, you've heard it for yourself. What about the issue of Inec not transmitting results electronically as promised? Is that going to be a blow on Inec? Considering the fact that Inec has the constitutional power to come up with its guideline, and that guideline must be followed by Inec and the public.
You see, this issue is that, what is the effect of it? The Electoral Act says this procedure for collation should be left to Inec. As empowered Inec, you transmit results as the Inec provides. So it has left Inec with a discretion. And with that discretion, Inec has now made regulations to say, how do we determine this? They've now made selection to transfer results in the manner prescribed, Section 60, subsection 5. Section 60, subsection 5.
Yeah. The presiding officer shall transfer the result, including total number of accredited voters,
shall transfer
and the result of the ballot in a manner as
prescribed by Inec. In a manner as prescribed by Inec. So how does Inec prescribe the manner? You go to the regulations. So you see that it flows directly.
So guys, you've heard it for yourself that Inec has the power to determine the way they want to collate the results. And we all know that the Inec chairman came out repeatedly to give us this guideline that says that results will be uploaded real time from the polling unit to the Inec portal. But that didn't happen. Just take a look at this video.
For elections. Of these innovations, most Nigerians are more familiar with the bimodal voter accreditation system, the BVAS, which doubles as accreditation device as well as the upload of polling unit level result sheets on election day on or to the INEC result viewing portal, the IREV, in real time. These innovations have increased transparency and public confidence in the electoral process. They are also part of the legal requirements for conducting elections in Nigeria. The combination of BVAS and IREV portal have come to stay as a means of voter education and transmission of election results. Nothing will change that reality. Let me once again reassure Nigerians that there is no going back on the deployment of the bimodal voter accreditation system, BVAS, for voter accreditation. There is no going back on the transmission of results on the INEC result viewing portal in real time on election day. There will be no incident form that enables ineligible persons to vote using other people's permanent voters' cards during elections. We are committed to ensuring that the 2023 general election is transparent and credible, reflecting the will of the Nigerian people. On this note, let me seize this opportunity to respond to a story emanating from a section of the media that the Commission has decided to jettison the uploading of polling unit level results in real time on election day. It should please be disregarded as fake news. The Commission will upload polling unit level results, and citizens will have access to those results in real time as we upload to the polling units. This innovation was introduced by the Commission. The Commission cannot turn around and undermine itself. This technology has come to stay. We'll upload polling unit level results from the polling unit. Citizens will have the right to view these results. Preparations for
So guys, you can see that this is a very big setback for the INEC chairman and for Tinubu himself, because they can't escape this. You know, this one has hooked their neck. So guys, I'm going to allow you watch this video in full. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section
these
below.
Issues have been brought up, which of course the ruling and the positions of the tribunal, and if it goes on to the Supreme Court, we have a far-reaching implication and lessons on our electoral process and, in fact, the electoral law. Let's get some perspectives on what these means, these petitions, without necessarily having to touch on what the honorable justices, the judges will be discussing, or the lawyers will be arguing in court. We're looking at some of the issues that have been raised by this matter. I have a very senior lawyer and also a very experienced official of the Independent National Electoral Commission. If I was a former, he is the former Director of Voter Education and Publicity at Inec, Mr. Oluwole Osaze Uzi. Thank you so much, Mr. Osaze Uzi. It's good to see you again. After the long...
It's been a while.
Yeah,
I keep saying Director of Voter Education. I was also Director of Legal Services. You have brought me here to
but that was your last... But that was your last assignment.
Not my first, but my last. Yes.
Very much. It's good. I mean, your competence is not in doubt at all. And I mean, respect to your years of service and experience. Thank you so much indeed for taking time out to do this with us. Well, as a lawyer, how would you describe this time in our political and electoral history?
Well, it is we live in interesting times. A lot of controversies were raised as a result of the conduct of the elections. Certain things were being the revolution brought about by the change in law. In the injection of technology into the process it's in the front burners. What is the effect of the deployment of technology? Don't forget that in 2015, the issues of the card reader, that was not the first time, but that was the time that it was at the forefront. So the card reader came in. What is the legality? What effect will they have if it's complied with? Then we had the Court of Appeal and the judgments of the tribunals, which went one way, but the Supreme Court, in its wisdom, went the other way about the deployment of the card reader, its use and its effect. Then came the Electoral Act of 2022, and much more usage and injection of technology was brought into the process and into the legal regime. So things are new. Some of the cases that were binding on the courts and on the commission will no longer bind the commission because the law has changed. So with the changes in the law, what will be the position of compliance, non-compliance with those statutory provisions? Those are some of the issues being thrown up in these time as we go into the next phase. We've done the elections, we've done the pre-election, we've done the election stage. Now it's the post-election, is the dispute resolution mechanism by way of petition brought into the system by law. That's the stage we're at now.
It's an interesting stage, isn't it? Very much. And there's a lot of pressure being put on the judiciary right now. Is it unexpected?
I wouldn't say so, but not just right now. The pressure started in the pre-election stage. I think we've been here a couple of times and we told you that the last count, if I remember correctly, more than 700 pre-election cases were filed in the Federal High Court, and almost all, without exception, went on to the Court of Appeal, and there's still quite a number pending in the Supreme Court. Some have been determined. There's still quite a number pending in the Supreme Court. And in between now, we've have the election petitions. A lot of those ones dealt with pre-election issues, intra-party issues, arising mainly out of the primaries of the political parties. So it was intra-party between the political parties themselves. Now we've gotten to a stage where it is inter-party between the winning party, if you so use that word, and then those other parties that lost out in the election. And in all of this, whether pre-election or post-election, Inec is a party, mandatory party in all these proceedings.
I don't know. I think in 2011 or 2015, we saw maybe the highest number of petitions that came out of the presidential. I can't remember. But it does look to me that that scenario is playing out. You saw how many petitions in Lagos alone.
That's right.
And I'm not sure Inec has come out to announce how many petitions, 5 officially that we know on the presidential election, yes, against the victory of Bola Tinubu. I mean, what does the number of petitions and the challenge, going to court, what is the implication on the electoral process? Does it have any implication?
Well,
does it say anything? Because there's those who argue that, look, I mean, when the process is smooth, foolproof of fraud and manipulation, there is a tendency that people will not challenge it.
That's one school of thought. And yes, a lot of people believe that the better, more credible election is the less likelihood that it will be challenged. There are those who believe so, and that may be so, but we don't have any scientific basis for putting that forward. But it's just a belief that a lot of people share. But it depends on the players, active players, and whether they feel wrongly done by what Inec has done or not done, as the case may be. And don't forget, Inec has not come up with a total number of petitions yet, because I don't think it knows. I don't think it has been said with all the petitions. And you have to remind viewers that these are the petitions arising out of the presidential and National Assembly elections. There's still time within which the state assembly elections will also come in, and a lot, I expect a deluge in that one, a lot more. And then there's still the governorship petitions as well. So yes, it's a busy time for the tribunals, it's a busy time for the courts. Court of Appeal sitting as the presidential tribunal, sitting to hear the presidential tribunal, full complement, and then the Supreme Court will also hear the presidential election petitions arising therefrom, and also the governorship elections will ultimately end up in the Supreme Court. All of that will stop in the National Assembly, and state assemblies will stop in the Court of Appeal.
Give us a sense of what stands out to you. I mean, let's look at the issues now that have been presented in some of these issues. Which of these issues really stand out for you that you think that it's of importance and need to be critically looked into?
Well, quite honestly, all are important. All are quite important. I tell you why I say that. Imo, for example, in the current governor's petition, I wouldn't say people didn't take it seriously, but people had forgotten about it. They thought the main challenge were from those people who came first and second. They thought the main challenge Wonsu of the APP then, Mr. Wonsu was the main challenger because he came second. He was runner-up to Ihedioha. So a lot of people were concentrating more on those ones, and think when the thing where those petitions were disposed of, say, oh, that's it. Not knowing that somebody who came fourth might also have a successful petition, as it turned out it happened. What stands out? A lot of things stand out. So we cannot rule out anything at all. But one, what is the effect of technology? What role did it play? Is it mandatory? What is the effect when there's non-compliance with the IREV? And people don't realize that different processes, not just the IREV. People concentrate more on the IREV, but the IREV is actually just one stage in that collation process. As you said in your opener, Inec is saying, or maybe the process known to law is the manual collation. Is that correct? These are all the issues the courts will have to sieve through. There's the issue of the vice presidential candidate, taking the Peter Obi petition. The issue of the vice presidential candidate. Can you be, well, Section 35 of the Electoral Act says you cannot be nominated for two different constituencies or by two different political parties. Those things are clear. And it is alleged that the vice presidential candidate, Shetima, was nominated for two different constituencies. One, the Senatorial District in Borno, and the second one is the presidential constituency. The whole of Nigeria is one constituency, and his Senatorial District in Borno is another constituency. You cannot be nominated at the same time for the same election for two constituencies. So the issue is that
the electoral law says in that area, says Section 35, it says where a candidate knowingly allows himself to be nominated by more than one political party or in more than one constituency, his nomination shall be void. So which of because there are two nominations that are involved, is it the earlier one or the latter one? It's not explicitly stated here.
Yeah, there are two angles to it. One, have you been nominated by two political parties? That's not the allegation. That's the first one. The second one, there are two issues there. Second complaint is that have you been nominated for two different constituencies? And from what I've seen in the media, from the petitions, they attached the nomination form as a senatorial candidate. And we also know that it was returned as a vice presidential candidate. So that is the issue the tribunal will have to sieve through. That's another very important issue. But the issue is this. I think I've seen some of the issues being canvassed. And part of the defense is this. If he withdrew before his nomination, the tribunal will now have to look at it. Does that apply or it doesn't apply? If he has withdrawn, successfully withdrew from the senatorial election, then could he be nominated for the vice presidential? Probably so. So now it's a question of proof. You cannot be nominated for both positions at the same time. So were you able to, can you show that, yes, I was nominated for the senatorial district election, but I withdrew before I submitted the form as a vice presidential candidate, not forgetting that there was a placeholder. What now has become called a placeholder.
The politicians have brought it to
was there an overlap, or there was a distinction? There was a distinct time frame between his withdrawal and, again, you also have to prove that he was nominated for the senatorial district as well. So these are some of the issues that
the issue exactly that the lawyers need to argue is whether or not there are two valid nominations by the same political party at the same time with INEC, and those who also argue
not two political parties.
No, one. The law says by more than one political party.
That is one, but that's not the case. It's the second. I read that the second aspect of it.
Yeah.
Or two different constituencies.
By more than one political party or in more than one constituency.
That's the bit that happening.
So there are two scenarios played in that section alone.
Yes, in that section.
Two scenarios. Yes. Nomination by two political parties.
That's correct.
And nominations by one political party, but in two constituencies.
Correct.
So, but the lawyers need to prove whether or not there are two nominations that are valid at the same time.
That's
but people will argue that, look, is the onus not on INEC to take action when such thing? This is not the first time we've seen. In the case of Atiku Abubakar, he was already a governorship candidate in Adamawa State.
He was not a candidate.
He was elected. Yes. Actually.
Elected governor.
In the case of Goodluck Jonathan, in Bayelsa, before he came to be the running mate of the later President Yaradua.
Yes.
So we've seen this kind of scenario, but this was a pre-election issue. This was not an election. I mean, this didn't happen after the election.
No, we need to explain those. They're not the same. In the case of Atiku Abubakar won the election. First of all, there was no constitution in existence at that time. After the reconstitution, after the establishment of Inec met with political associations and said, look, what's the roadmap? How do we move forward? And it was agreed at that meeting that, look, okay, we will not, there's no constitution in place. So there has to be a legal framework to guide us. So they agreed that each election will have a separate decree, with another military rule, to guide the process. And that's exactly what was done. In that case, there was a Decree 17 which established Inec. And then there was a decree for local government elections which was conducted by Inec. There was a decree for state assembly elections. There was a decree for national, and there was a decree for governorship presidential elections. So each one had. In this particular case, under the decree for governorship election, Atiku Abubakar was nominated and won the election as governor of Adamawa State. Now, the issue was that could he also be, and later on, President Obasanjo took him as his vice presidential candidate. And the court case went to court, by the way. What should happen to the seat he was vacating as governor? And A.B. Mahmood, the former president of the NBA, who is handling this on behalf of Inec, represented Inec in that case where Inec was taken to court over who should be, what should happen. Should his deputy just step in, or should there be a by-election and everything else? The case went all the way to Supreme Court, and Supreme Court said no, the deputy can't step in. That's how that was resolved. So that's a slightly different. First of all, the law was different, and it's different from now.
So this was a development.
Much subsequent development. Then the Bayelsa case, it's similar to this, but the difference was that you, as a governor, you can contest any position. As a senator, the deputy senate president contested the governorship of Delta State, for example. The law doesn't forbid that. You are nominated, you are cleared, you've already been elected. As an elected official, you can contest any other position you so choose. That's possible as well.
So interesting scenario playing out. But the issue of Section 838 of the INEC guidelines, which has caused a lot of furore now, as we're seeing, the electronic transmission of result. So it says, on completion of all the polling units voting and result procedures, the presiding officer shall, and one, electronically transmit or transfer the result of the polling unit direct to the collation system as prescribed by the commission. 2, use the beavers to upload a scanned copy of the Form EC8A to the INEC result viewing portal IREV as prescribed by the commission. 3, take the beavers and the original copy of each of the forms in temper evident envelope to the registration area and ward collation officer in the company of security agents the polling agents may accompany the presiding officer to the RA Ward Collation Center.
Correct.
Those are the provisions of. So some people will ask the validity of the Inec regulation, or how strong in the body of our laws. There's a constitution, there's the electoral law, and the Inec regulation. Give us a sense of what this means altogether.
Yes, there's a hierarchy of laws. Absolutely. And of course, as you rightly pointed out, the constitution is supreme. The constitution says so, it is supreme. All other laws, guidelines, regulations derive their strength, their authority, their existence to the constitution. It's the ground norm, it's the fountain of all other laws. And so because of that, the importance of that is that if it has made provision for cover the field, if it has made provision, no other law can try to expand it, except the constitution says you can expand these powers, for example. No other law can do that. Next to it is an statute, the Acts of the National Assembly, because it's presumed that the National Assembly is elected by the people. So they are the people's representatives. They make laws for the country, assented to by the president, who's also elected. Then you have regulations and guidelines. Regulations and guidelines are made by people who generally are not elected. They're parts of the executive. They are appointed. So Inec, for example, is composed of appointed people. Nobody in Inec is elected. So that being so, they are not direct representatives of the people. So any regulation, any legal instrument they make is subservient to that made by the representatives of the people, which is the National Assembly. So in the hierarchy, there should be no conflict between it, regulations, guidelines made by the commission or any executive body. There should be no conflict with the statute, which is a superior instrument. There should be no conflict. And then below guidelines and regulations, you have, because guidelines are bylaws, you cannot conflict with the substantive, with the major law. Then you have manuals and other procedural instruments that.
But how solid is the regulation? Because this section that I read out, and including section 48 of the regulation, because INEC prepare a regulation ahead of every election. I assume that there is except if there is a need for change, isn't it? But there is a regulation of 2022 which was supposed to guide the operation of the election of 2023. How solid and how solid can this regulation stand because of the controversy that has been generated? Is INEC mandated? Because INEC has, in its position at the petition, I said, look, it's not mandatory for us to have done what you are asking us to do. The IREF was supposed to be a subsidiary.
No, that is editor's choice. We have to be very careful about that. You have to quote what Inec said.
Absolutely.
And a lot of what I have seen are editor's language. Now, so while you're looking for that, let me explain.
No, go ahead, please.
Good. So you see, this issue is that, what is the effect of it? The Electoral Act says this procedure for collation should be left to Inec. As empowered Inec, you transmit results as the Inec provides. So it has left Inec with a, discretion. And with that discretion, Inec has now made regulations to say, how do we determine this? They've now made the regulations. That's why you say paragraph 38 and 48 of the guidelines, amongst other provisions of the guidelines, are supposed to guide these issues. I think in section 60, subsection 2, makes issues of leaving the discretion to Inec about how things should be dealt with.
Of the Constitution, right?
No, of the Electoral Act.
Yeah.
I think it's
section 60, right?
I believe it's section 60. Now, they say that to be transmitted, 60 check subsection 5
Counting of votes, recount post-election procedure.
To transfer results in the manner prescribed, section 60 subsection 5. Section 60 subsection 5.
Yeah. The presiding officer shall transfer the result, including total number of accredited voters,
shall transfer
and the results of the ballot in a manner as
prescribed by Inec. In a manner as prescribed by Inec. So how does Inec prescribe the manner? You go to the regulations. So you see that it flows directly from the Electoral Act itself. Having said that, you go further into the Electoral Act. You now see that there are certain protocols to be observed, not just in the regulations, but also in the Electoral Act itself, in a manner to prescribe. What is the manner prescribed? You just read paragraph 38 of the guidance. That is part of the manner prescribed.
But that is rock solid. That cannot be.
You cannot fault it because it doesn't contradict the Electoral Act.
Yes.
It derives, it flows.
So the place of IREF is stamped here in the electoral law, isn't it?
In a manner prescribed, and the manner prescribed. No, you see, you're jumping the gun.
No. I'm asking.
And that's
no, yeah. He says, look, Mr. Oluwale,
yes.
He says, use the beavers. Stemming from the section 38, the subsection 2 says,
yes.
Use the beavers to upload a scanned copy of the EC8A to the Inec result viewing portal as prescribed by the commission. So there is actually.
But read the previous.
It says electronically transmit
or transfer
the result of the polling unit
to
direct
the
to the collation system.
Collation system. And that's the mistake a lot of people make. Collation system is where you should transmit results to first. And then the IREV. People don't seem to get that. And we
so does it mean that the IREV is not cast in stone?
I don't know.
So the collation, no,
you
the
report that plain and simple.
Yeah.
I don't know that's cast in stone, but it doesn't say so.
No, you made reference. So electronically transmit or transfer the result of the polling unit direct to the collation system as prescribed by the commission.
And then
collation system.
After you do that,
is the collation system a manual process?
Wait now, it's after you do that.
Yeah.
But you just read it. Transmit or transfer.
Electronically.
Electronically, that's the point. Electronic transmit or transfer to the collation system. That's first place. Before it goes to IREV. Now read the second one. Without goes to
use
the IREV.
Use the beavers to upload a scanned copy of the EC8A to the Inec result viewing portal as prescribed.
That's after doing the first one. And people always just jump to conclusion, oh, it's just IREV. No. There's what they call the collation system. And my understanding of it, the collation system is probably the back end of the IREV. It should, it's like a mirror. It should replicate that. But first of all, take it to the collation system. And then later on go to the IREV. That's what the regulation says. It's not me making it up. You just read it. I'm happy you read it. So when people say, oh, I didn't see the IREV, I didn't see the IREV. The law did not say sign to IREV first. It's time to the collation system. After the collation system, then you take it to IREV. But I think the language used is mandatory, by the way. That's my own honest view. But the collation system is different from the IREV according to the regulations. Because if you look at disputes, for example, I think if you check, if you have time, your producer will check section 64 of the act itself.
Electoral. Yes. 60 what?
64.
Yeah. Which says that's
64. Let's check
64.4. Okay.
Yes.
It said a collation officer or returning officer at an election shall collate and announce the result of an election subject to his or her verification and confirmation that the number of accredited voters stated on the collated result are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under section 47 of this act, and B, the votes stated on the collated result are correct and consistent with the votes or result recorded and transmitted directly from polling unit under section 64 of this act.
Correct. So there are two things there. First of all, accreditation figures. Accreditation figures have been entered into the manual result sheet. So you look at the manual result sheet. Does it tally? I think it's correct and consistent. The word used by the law. Correct, first of all, and consistent with that in the beavers. So you must physically examine the beavers to look at it. And then the second thing you do is now look at the scores. Party A, Party B, Party C. Are they correct? Is total correct? Are they correct? And are they consistent with what has been electronically transmitted from the polling units?
So, this is where I would love us to anchor.
Okay.
Mr. Mahmood, in his petition for Inec, when he responded to his reply, says, quote, there was no collation system of the third respondent, which is Inec, to which polling unit results were required to be transmitted by the presiding officers. A prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E in the presidential election. The electoral umpire.
Can we pause and break it down?
Absolutely.
Well, read the first sentence.
It says that there was no collation system of the third respondent, which is Inec, to which polling unit results were required to be transmitted by the presiding officers.
No collation system, but now the tribunal will have to determine, in view of the law.
It now says the prescribed mode of collation was manual collation.
That was also, I find very interesting. Prescribed mode is manual collation. Well, you just read that, and that's actually what it says. It didn't say you should collate electronically. There's nowhere in the law, nowhere in the guidelines you see electronic. Go back to your 64.4. Go back to 64.4. Go back.
A collation officer or returning officer at an election shall collate and announce the result of an election subject to his or her verification and confirmation
verification and confirmation. That's what is required with it electronically transmitted. But quite rightly, collation is still now
manual.
Give me from this point, from that point,
E8B, E8C, and E8D.
But before you start that process, you must go to the electronic ones and say, are these figures consistent? Yes. It doesn't say start collating from the beavers. It doesn't say start collating from the transmitted results. It says start collation. Before you start collation, look at this, and the figures are the same. Now you gather all the EC8As together and start. So in that sense, it's a manual process.
Interesting. Inec is spending several billions of naira on that. They've actually allocated, I can't remember, is it 3 billion or something?
I read it on social media, but I don't know whether that's an official statement of the commission. But yes, 3 billion naira for defending
for its own petitions. And
legal expenses, not just the defense, not just the lawyers' fees, but the logistics of moving things around, of certification, all sorts of logistics associated with post-election litigation issues.
I mean, are you one of those who subscribe that the courts should televise these proceedings?
I have mixed, quite honestly, I have mixed feelings about it. You don't want to turn it into a circus, into a jamboree. Even in the US, where a lot of states allow televised issues, you find the O.J. Simpson matter, for example. That's one recent memory, and the controversies arising from that. Some of the lawyers, some people were just playing to the gallery. Serious controversies about it. We've not really gotten over it. Marcia Clark, one of the major prosecutors, Eddie Cochran was one of the major defense people, and there was controversy about it. Kenya did it, and I think
presidential petition,
yes, I think Ghana did. We all watched that. It was interesting viewing in certain regards. People say for openness, it's open to the public. Probably for openness, maybe parts of it or the whole of it probably should be transmitted.
Interesting. But I mean, as a lawyer, I mean, this is just my own, I'm asking you for the sake of our viewers who need to understand also. I mean, you made reference to the case of Hope Uzodinma and the prayers he went to court. He's had a specific prayer that he asked the court to do, and he asked the court, and technically a lot of people will argue, and I'd like you to let our viewers know how things work in terms of judiciary. I mean, it comes down at some point to how prolific, on how technically sound some of these lawyers present their cases, isn't it?
It depends a lot on that, the kind of case presented, the evidence presented, and the courts have to give judgment predicated on what they see before them in that particular petition.
Not on emotions.
Not on emotions. And I think there's a beautiful article in today's This Day, Legal, where some issues were discussed. It's justice according to law. So you must follow the law. You don't do it on emotions. You don't do it on what we see on social. I have seen a lot on social media, and it's so easy to be persuaded one way or the other. But some of those things will not stand the scrutiny of a trial. They will not stand the scrutiny of cross-examination and of evidence. You cannot tell, for example, that sometimes old videos they bring to you and you see on social media and you assume that it is relating to this election. For example, some are correct, some are not correct. Sometimes people are not willing to come to testify. Sometimes there's no time. If you don't front load their statements, for example, if you have not said you are bringing Mr. Ozi as a witness, it's very...
And they are time specific.
It's very time, it's 21 days. And
very technical. I mean, so all of these things are there. Interesting. And I see why the politicians also spend a lot of money getting the best of the lawyers. I see a long list of senior advocates of Nigeria. This is their time.
Yes, Shehu, this is their time. Our politicians do no longer allow the people to decide who governs them, to decide who rules them. They want everything to be determined by the courts because they know that the judges are their agents, because they know that they've taken hold of all the constitutional bodies in Nigeria. They've taken hold of all the government bodies. You know, they control them, and that is why any little thing they tell you, go to court, because they know they've set their agents in court who are going to give them justice. So guys, we are looking at our judiciary, all eyes on our judiciary. We are looking at them, we are looking up to them. We are believing that it's not going to be, it's not going to be as usual. They have to stand up this time to give justice to all these cases. So guys, you have heard it for yourself. Let me know what you think about all this in the comment section below. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you. So guys, so much trouble for Tinubu and Shetima, so much trouble for the APC, so much trouble for Nigeria, because if we don't elect the right leaders, the problem falls back on us. You know, our political class, they are always safe, they are protected because they have the money, you know, to attend to all their needs. But it's the ordinary man that suffers in Nigeria. Honestly, these are some of the things that we are looking forward to, you know, changing in Nigeria. We just want a new Nigeria. We want a Nigeria we all can call home. We want a Nigeria we all can be proud of. We want a Nigeria where our politicians are not the one to dictate for us. We have to decide who governs us. We have to take, you know, we have to take it by force, as in deciding who becomes our next leader. We don't have to leave it in the hands of these our politicians that we know don't even mean well for the Nigerian people. So guys, that is where we are today. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you.